Imagine being asleep in your home when out of nowhere, FBI agents break down your front door, throw in flashbang grenades, drag your family out at gunpoint, drag your wife out half naked, and then they realize that they actually raided the wrong house. Now imagine the government's response to you suing them is not an apology or anything like that. Instead, they argue that you can't bring a lawsuit against them at all because the agents were exercising discretion. That fight already made its way all the way to the United States Supreme Court, where the family here won a 9-0 unanimous ruling. But now there's another major development in this case. A federal court of appeals has just issued a brand new ruling involving government immunity, and the family here is telling the 11th Circuit that's re-reviewing this case that the decision there further proves why the FBI should not escape accountability for raiding the wrong house. So let's break down what is now developing in this case. Now, before we get into today's video, I want to thank the sponsor of this video, which is TacPack. TacPack is a subscription-based box that delivers tactical and EDC gear to your front door every single month. And right now is a great time to sign up because the upcoming June TacPack Plus box is packed with some incredible gear. This month's box features a lot of other new gear, range gear, and also an additional plus item that you absolutely do not want to miss. And so if you're interested, you can check them out using the links down below. And right now, if you sign up using my code ARMED, you'll receive a free tactical gift with your first subscription. Now, if you've been following the channel for a while, you will know that the Supreme Court recently issued a 9-0 unanimous ruling in favor of the Martin family who were victimized by the FBI during a wrong house raid. Now, back in 2017, the FBI agents executed a pre-dawn raid in a suburban Atlanta area. Instead of going there directly, one of the officers used his personal GPS device, I believe his iPhone, and his GPS, what he claims, routed him to a completely different address than the correct one that was supposed to be, raided and the right one that was on the warrant. Instead, it took him to the home of Katrina Martin, where she lived with her boyfriend and their 7-year-old son at the time. When the FBI agents arrived at the home without warning, they smashed in the front door, detonated flashbang grenades inside the house, and then they pulled out Katrina Martin and her boyfriend who were hiding in a closet with a shotgun, and the FBI pointed guns at the family, pulled out Katrina Martin half naked, also pulled out their 7-year-old son, and detained all of them. Now, after the agents had detained the family, they did a quick search of the home, and while performing that search, one of the agents noticed some mail on a coffee table and noticed that the address was different. That's when they kind of realized that they had the wrong house, and that's when they kind of had this huge oh crap moment, we raided the wrong home. The officers then left the home, told the family that they would be back to explain. The officers then went about 3 homes down, which was actually separated by a cross street, so about a block away, and then they executed that raid against the correct house. Now, in response to this incident, the family then sued the FBI. They brought a claim under the Federal Tort Claims Act, also known as the FTCA. The government claimed immunity under the discretionary function exception to the FTCA and asserted that this case must be thrown out and they could not be sued. The lower court on review originally sided with the FBI, but the Supreme Court eventually stepped in with this case. They granted review and then issued a 9-0 decision against the FBI. The Supreme Court made something very clear in that unanimous ruling. You don't automatically get immunity just because law enforcement exercised judgment. The government has to show that those decisions were grounded in actual policy considerations, not just mistakes. Because of this, the Supreme Court then sent the case back down to the 11th Circuit for a re-review of this case and told them to apply the correct standard. Now, recently, the 11th Circuit reheard arguments in this case following that Supreme Court ruling, and one of the themes really that were repeated during those arguments was essentially, where is the line between protected policy decisions and ordinary negligence? The panel appeared concerned that under the government's theory, nearly any mistake made during a law enforcement operation could potentially be shielded from liability. Now, several judges also pushed the government to explain how its position was consistent with what the Supreme Court just said in that unanimous ruling, and the 11th Circuit is now reviewing this case and is set to rule on this issue once again. But now we have another important development in this case. The Martin family has filed a supplemental authority to the 11th Circuit pointing to a brand new appellate court ruling coming out of the 5th Circuit in a case called Morris versus the United States. Specifically, the 5th Circuit examined whether the FTCA's discretionary function exception protects government employees when they are negligently carrying out an operation after already making a policy decision. The 5th Circuit said that that distinction actually really matters. According to the 5th Circuit, once a government employee makes a policy-driven decision, a failure to properly execute that decision is not automatically protected by immunity. So in other words, there is a major difference between making a discretionary choice and botching its execution. That distinction may sound very technical, but it goes directly to the heart of what's going on in the Martins case. The Martin family argues that even if the FBI agents had discretion in planning the operation, the actual conduct being challenged is much simpler. They raided the wrong house. The plaintiffs argue that raiding the wrong home, deploying flashbang grenades against innocent people in this family, pointing firearms at this family, and detaining these individuals, who were never the targets of the warrant at all, is an actual operational failure, not just policy judgments by the FBI. And according to the new Fifth Circuit ruling, operational failures are generally not the type of conduct that the discretionary function exception was designed to protect. The supplemental filing also highlights another important point from the Fifth Circuit ruling. The court explained that the allegedly wrongful conduct must actually coincide with the policy considerations. It is not enough that the conduct merely occurred somewhere near a policy decision. That point is significant because one of the government's primary arguments has been that everything leading up to the raid involved discretion. But the Martin family says that misses the actual point. Even if planning involved discretion, executing a warrant at the wrong address at the wrong house is a completely separate issue. And that's exactly the discretion that the 11th Circuit judges appeared most interested in during these recent oral arguments. The Martin family now appears to have additional momentum because of this new Fifth Circuit ruling, and that's why they submitted it to the 11th Circuit. And they already received a unanimous ruling by the Supreme Court once before, and now they have additional support coming out of the Fifth Circuit based on this new ruling. The 11th Circuit seemed very skeptical of many of the arguments that were put forward by the government during those oral arguments, and now the plaintiffs have pointed to this new court decision coming out of the Fifth Circuit that further supports their position and why the discretionary function exception does not apply in this case and why their lawsuit should move forward. So this case continues to move in a very interesting direction. The Supreme Court unanimously ruled against the government's position. The 11th Circuit has now reheard arguments in this case in light of that Supreme Court ruling. And now the Martin family has submitted a brand new supplemental brief to the 11th Circuit pointing to a new ruling that came out of the Fifth Circuit dealing with a very similar issue. And the question that still remains here with this case and that the 11th Circuit will have to decide is, can the government claim immunity when agents raid the wrong house? That is the overarching question that the 11th Circuit now has to grapple with. So that's the latest update in this major Fourth Amendment accountability case dealing with, this wrong house raid. As soon as the 11th Circuit issues a new ruling or updates this case, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm and just tells the algorithm that you appreciate this content, and so it shares it with more people. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.